Good afternoon, ladies and gentlemen. Welcome to this data breach session. The title is Tips for Dealing with Personal Data Breaches under the GDPR, but we're going to look a bit back and a little bit forward, but the idea is at the end you will have lots of good ideas about dealing with data breaches. My name is Stewart Dresner. I'm founder and Chief Executive of Privacy Laws and Business. That's the world's longest running publication on the subject. We have both an international and a UK editions, and everything's available on our website. And also we run the world's longest running independent privacy laws conference, which we hold in Cambridge each year in July, this year, 1st to 3rd of July. I prepared some tips in advance, which are too detailed to go into now, so if anyone wants them later, if you give me your email address, we will send you information about data protection, data breach tips, and we will use it for data protection purposes, and you can opt out at any time. So let's get on with what we're here for. So data breach under the GDPR, this was a concept. Data security is a concept been running through data protection laws from the beginning, really, although in the early laws they were mentioned very briefly in passing, more or less. It was the state of California about 20 years ago that really made a thing of data breaches by having a reporting duty, and this was very attractive to Americans because they're a bit weaker on rights but strong on taking action. So, and it appealed to the tech community as well that data security was something important they had to look after. So they started with California, and those laws rolled out for the following 20 years across the other states. And this zeitgeist was picked up by the GDPR. Of course, data breach and data security was certainly a principle in the 1995 directive, but greatly strengthened when it came to the GDPR. And there are several articles on data notification, data breach notification, articles 32, 33, 34 in the text, which we all know and love. And we know, therefore, that there's companies, organizations have to have proper data security provisions and have to take steps if there are any data breaches to notify the national authority, notify the individuals involved. And this has been there have certainly been lots of notifications. We heard yesterday from the Irish Commissioner that there have been more than 4,000 notifications since May, just in Ireland, which has a population of about 5 million, I think. Anyone from Ireland got that number wrong, tell me. But I think it's about 5. Anyway, and they've greatly increased. We heard from the speaker in the previous session, which was also on data breaches. In the Netherlands, notifications increased a great deal as well, and in the UK. So this is a trend. Lots of data breaches have been notified. But this session is more about preventing and security measures, how to prevent data breaches, and what to do if you suffer that problem. In the previous session, great idea of risk registers, and the idea, which I'll mention again, Professor Dennis Hirsch from Moritz University in the States came up with a great idea, which is that as each national authority receives all these notifications, they could be consolidated and they could be published at the end of the year, not just on an individual basis, but ranked according to geographical area, according to sector, by company, and then you can have like the top 10 worst data breaches, which will be then available in each country, and then could be consolidated European level. I'm certainly going to take this up with the UK Commissioner and also suggest it to the Chair of the European Data Protection Board, because this could then bring to the fore, and no organisation would wish to be on this register. So that's a great idea. Now, moving on to the people on the panel. First of all, Laura de Boel on my left. It's her idea for this panel, and thank you very much for suggesting and inviting me to chair it. You're a lawyer spending all your time on data protection law and very much focused on GDPR. You're an of counsel there. Your law firm is Wilson Sonsini. It's so long that people can only normally remember the Wilson Sonsini, but it's got 4 letters. If law firms only kept down to 2 names, that would be all right. But Wilson Sonsini, we'll call it that. And you have a distinguished group of lawyers there, and you do work for many clients, including the Belgian Data Protection Authority. I think you said that in your biography, yes? No?
No. Advise clients in dealings with...
Oh, advise clients in dealing against, or, yes, dealing with Belgian authorities. So, sorry about that. Correction, everyone, they advise clients in dealing with the Belgian National Authority Commission. Okay, thank you for that correction. Next we have Ioan. He's with Kroll. Kroll. He will tell you a bit about it, but they do cybersecurity investigations. So there's a lot of practical stuff to do with data protection, with cybersecurity. You're in the London office, you've been there for 20 years, but you've also had help. You've helped the UK government sort itself out, giving advice on various matters to do with data security and also intellectual property protection, yes? Is anything wrong there?
I haven't been there 20 years, but I have been in the industry 20
In
years.
industry, yes. Right, okay, good. We're making sure our data is relevant, accurate, and up to date. And you were formerly with Airbus.
Yes.
People who build planes.
Yeah.
Yeah, they do build planes. Yes, Airbus, good. And head of security audit there and corporate security. So you have a lot of practical information. And a great thing in your biography here, it says here that you included psychological strategies and gamification.
Ooh.
That's the only time I've had introduced anyone who had those aspects in their career. So if you have a chance, you can share that a bit with us. Okay, so now we're on to Barbara Radon from Zeotap. Zeotap is a brand new company, so in the last 5 years anyway, and you've been there for a few months, and you have previous experience as a lawyer at NER, a German-based law firm, and also a global legal counsel role at SpotCap. Have I made any mistakes yet? No, that's great. Okay, but you do speak 6 languages, and that's good. Not all equally fluently, but that's for a British person, that's pretty impressive, and that's very good. And you're working on a doctorate as well. So, very busy lady. Right. Now, we've got Helena. Let's turn over the pages here. We've got the, now, you're with Mastercard, and you've been there since June 2017. You're a data protection officer for the Europe and Africa, EA area. And I was pleased to see that you've previously worked as Senior Privacy Officer at Standard Chartered Bank. The reason I'm so pleased to hear about that is because when I set up the first newsletter, our first newsletter in 1987, Standard Chartered Bank was the first person to send in a check and say, yes, we'd like that newsletter. And they've been remaining a client ever since. So that's good, but not MasterCard. So they've got something to catch up with there. And before you were at the General Counsel at the Netherlands Authority, and even working with Alan Overy in Amsterdam and New York. So a very glittering and wide-ranging career there. Now, let's turn to Dina. Dina Kampouraki, you from Greece, and you've been in this field for a long time. You've worked with a mobile telecoms company, and you're also the National Data Protection Authority in Greece. We don't hear from very often, but you work there. And Secretariat of the Council of Europe. It's not well known, but people go from the national authorities to the Council of Europe and usually serve for 2 years, then go back to their national. 2 or 4 in your case. Okay, right. And now you're with the European Data Protection Supervisor's Office, dealing with the issues we're going to talk about today. And I turn the pages very quickly. So at the end, been waiting very patiently, we have Peter Eberl. How do I pronounce that surname? Eberl. Right, got it, thank you. From the European Commission, and Deputy Head for Cybersecurity and Digital Privacy Policy in DG CNECT. So that's a good place to be. And you also, CNECT has responsibility for e-privacy regulation, which we wait for. Can you forecast which year we're going to have an e-privacy regulation? This year. It will be this year. Probably. First half of the year, Romanian presidency, or?
It will be challenging.
We'll see.
No, it will be challenging for
It will be challenging. Maybe the second half.
But the finish has good chance.
Good chance. Okay, thank you. You heard it here. So it's been waiting for a long time, but it's complicated. And some people say, should there even be an e-privacy regulation? Because there's so many general principles in the GDPR. But that's ongoing debate. So far, the consensus is yes, there should be an e-privacy regulation. So you're dealing with that. And also the Network and Information Systems Directive as well, which is not as famous as GDPR, but maybe one day it will be, who knows. Yes, okay. And before that, you were Deputy Head of Unit for Electronic Communications Policy. Right, I think we've had a little bit of an introduction there. I've got some facts correct and some wrong, but all the ones that were wrong were corrected immediately, so no loss of reputation. And we carry on with good humour with Laura, who's going to moderate the session.
Thank you, Stewart. Ioan, to kick off the discussion, think it would be good if you could talk about the typical causes of data breaches that you've come across in your position.
Sure. So, hi everyone. Kroll is probably best known for our involvement in solving complicated disputes and incidents. I run the incident response for EMEA for Kroll in the cyber part of the company. So, generally speaking, when a company chief exec has discovered, usually on a Friday night, that a large amount of money's gone missing, the servers are inoperable, or something else bad has happened, and for example, somebody's releasing confidential information on the internet and trying to blackmail money out of the company, and it's generally my voice at the end of the phone. So I received the first call. The question is really broad. It could be literally anything and everything, but behind any incident, there's obviously a motivated attacker, unless the incident was accidental. But for the purposes of this conversation, let's assume that it's motivated. We see an awful lot of incidents that, at the bottom line, result from somebody's desire to acquire money at the end of the day, perhaps promote their cause, so hacktivism, or maybe even geopolitical statements, or something at the level of a government. We've seen a massive increase in fraud to the point where it's really becoming industrialized. People are using stolen credentials, stolen information, social engineering to work their way into conversations within the company. It's so easy to look at lists of credentials that have been stolen, or send somebody a phishing email and get maybe some login details for a cloud-based email system. If there's no two-factor authentication enabled or something like that people have to have in their possession in order to log in, then it's so easy for an attacker to just log in, look at the conversations, search across data, gather enough intelligence on the way that the company communicates and the roles of the people from the inside picture and LinkedIn and other sources, to then say, hey, I'm head of finance, please can you amend the details on this contract to pay the money into this bank, please. That's something that isn't generally in the press day in, day out, but we see incidents ranging from the tens of thousands to the multiple tens of millions quite routinely. Money just gone missing. And because those transfers are generally across national borders, unless you get there in time to try and stop the transaction, so realize that incidents happen fairly quickly, it's so hard to wind that back. It's also really difficult for police in the jurisdiction that you're in, let's assume it's the UK, because that's where I'm from, to then chase that, because the local police in the various countries aren't really resourced for those cross-border disputes. They're only really resourced for the things that are happening there in front of them immediately. So that's why it tends to land on our doorstep. That approach is becoming really industrialized, and it ranges from anything where some kind of access is needed to somebody just creating an email address that looks a lot like the company that people are expecting to see, using information from LinkedIn and other sources to say, hey, just do this. And they're just trying chancing their arm, just trying it. And it only needs to be successful once in every 1,000 times to be profitable at the end of the day, because the level of effort is almost zero. The level of technical knowledge is almost zero. So level above those kinds of manipulations, really, and attempts at social engineering, you also have poor technical hygiene. I think security professionals have been saying this for about 40 years, roughly, but it's still an issue where people have exposed services to the internet, or perhaps not locked down a configuration, or perhaps haven't communicated the reason for tightening the controls around the sharing of information in a good way to their user community, so they don't have support for doing it. And people use automated tooling to find this low-hanging fruit and manipulate it and use it against people. So things like remote access, for example, where there's only one factor of authentication, so just a username password needed, maybe that password's already been lost in another breach and it's available on a list and people just write a script to try it. There are also geopolitical issues, so not pettier. The US recently estimated that the impact of that piece of malware, which originated allegedly, according to various governments, from a spat between Russia and Ukraine, in a loss of about $10 billion. Various companies, so Maersk, for example, suffered a breach, and it basically disabled their whole enterprise. They said that that breach cost them in the region of $300 million, and that came from the weaponization of malware, which is plugged into USB key and just spread like wildfire across their network. So bottom line, good user awareness, practicing things like phishing attacks, making people aware of bad things happening, having good internal processes that relies on people and not just technology around things that matter, like changing bank details, for example, in the finance department. I'm sure there are lots of other examples you can think of. And good technical hygiene are all really important things that can help avoid bad things from happening, and that conversation with me on a Friday night. Thanks.
Thank you, Ioan. Now, if you didn't take those measures and you do suffer a breach, you may be required to notify. Dina, can you share your thoughts on the difficulties with notifying breaches and meeting expectations of regulators? And Dina's using a PowerPoint. That's the first PowerPoint.
Yeah, I will try to answer the question with PowerPoint. Thank you very much for inviting me here today, and thank you, Stewart, for the presentation as well. As Ioan mentioned, the data breach can be something very difficult to detect and something very difficult to correct as well. We, as the supervisory authority of the European institutions, I think it's not working, or yeah, okay, thank you, sorry. I would like to mention that as the European Data Protection Supervisor, we are the supervisory body for all EU institutions and bodies, and we have the same articles on personal data breach obligations for all EU institutions, so they are obliged to notify a data breach when there is a significant risk for the individuals, and they are obliged as well to notify the data subject as well. We have been monitoring the data breach since 11th of December when the regulation came into force, and we have produced some guidelines that are available on the website of the EDPS, providing specific advice on the EU institutions how to deal with this legal obligation and how to respond, to be able to respond in the case of data breach. We are also monitoring the work of the technology subgroup of EDPB, and we have been notified on the big number of data breach notifications that some member states already have, like the Irish DPA, like the UK DPA. They already have like 9,000 notifications received as we speak. And many of them are of significant risk and significant influence to the data subjects. Having said that, I would also refer to the complexity of the era of the new technology, and what Ioan already mentioned. The controllers might have to deal with technical environments with big data. They move many times the database on cloud. We have Internet of Things, and all this create a big difficulty when detecting an incident that have occurred, and of course when they need to correct and and take all the necessary measures. As a DPA, and as an EDPS, we expect that that the controllers are ready, and they have prepared internal procedures, which is very important to be able to detect and correct an incident of a personal data breach, they are able to identify when a security incident regards personal data, so they need always to invest in security measures. What we say is that because of the complexity, one very important aspect is to invest on resilience for the controllers, because a security incident or a personal data breach will happen. The thing is not, you cannot prevent it from happening, but you can be ready and able to detect it and take all the necessary measures to avoid the negative effects to the business, to the organization, and also to the individuals. So we need a lot of work on this aspect, and as already the previous speaker mentioned, awareness and training of the staff is very important. Another subject that needs to be taken care of is that the processors, according to the regulation, need to notify the controller when there is a security data, a personal data breach on their side, and they have to do it very quickly. And this is very fast, so that the controller is able to notify the supervisory authority within the time frame of 72 hours. So there is a need always for all controllers and organizations to review contracts they have with third parties and to put there a term, an obligation of a fast notification in case of a personal data breach. Having said that, the next step is that the controller are able to act. So for big organizations especially, we need an incident response team able to detect the incident and tackle the incident, which is the most important thing, is to try to deal with it. Effective communication, especially in big organizations, is very essential. We have seen from our experience that we had delayed notification because effective communication in the organization was not in place, and they delayed to decide on the need to notify. DPO, data protection officers, should be always involved in the very first phases and informed, of course, it's under the regulation, but we believe that he should be involved, because one of the main things that needs to be taken care of is when you have a breach, you need to assess the level of the effect of the risk to the individual, and this is something that can be more easily done from a data protection officer who has the appropriate knowledge to do that. Of course, the controller should notify when needed and should communicate to the person when also needed. In the end, after a security incident was tackled and finished, it's very important the organization to know what happened and why this happened, and they need to do all the corrective actions and, of course, to provide, again, awareness and training to the staff. So, summarizing, the difficulties that I can say for the organization and the controllers are, first of all, to be able to identify that a personal data breach took place. The second is to have an effective communication system in place to be able to respond very fast in case they have a data breach. To be able to assess the risk, which is very important, and we saw that we have received a lot of notifications that the risk was very low, and we shouldn't have received it. So we want to receive really important notification and not to be notified for everything, because this is not the purpose of the regulation. And of course, to be able to timely respond and notify the supervisory authority, and even if they don't have the full information, they can do this with notification in phases, and then provide more information in a next step. So I think I will stop here, and I will wait for more questions later. Thank you.
Thank you, Dina. So you indicated that the company should be prepared for a breach because it might happen to any company. Mm-hmm. Helena, can you share tips on preparing a solid incident response plan?
Let me try. How does this work? This is the... I go back. Yes. So you were speaking about the DPO. I am the DPO, and I'm always involved. So that's a good sign. What I wanted to give to you guys in the room is really some practical tools. And I know there's a lot on this slide, but I thought it could really be useful for you. So it speaks about what do you need to do before an incident, how do you manage it, and what are the supporting tools and templates that you should prepare beforehand. Now, to think about the key definitions, because in a company, people speak about incidents, they speak about crisis, they speak about data breaches. So make sure that incidents are security incidents. Crisis can be any kind of crisis. Data breaches, that's a legal qualification. And in our firm, that's the DPO who does that. Okay, so make sure that people understand the difference. Then also be very careful who is in the incident response team. Yeah? And what are their roles and responsibilities? Because once something happens, you don't want to have the lawyers drafting the communications drafting the notifications to the regulators, the incident response people doing the security job, etc. So you need to be very clear. You have to have in your document really roles and responsibilities. And make sure that the authority is clear. So who actually decides what? If not, you have to go to the CEO all the time and ask for permission, and the poor guy or woman will not sleep for a week. Okay? Managing an information incident, so of course the intake, we were speaking about it. Triage. Triage is something that needs to happen really within the first hour, because as these things tend to happen on Friday evening, you need to know, do I need to call the CEO? Do I need to call the Chief Privacy Officer? Who do I need to call? What do we need to do? And so triaging is very important, and it has to do with the risk. Then, of course, the legal analysis, the communications, containment and remediation, very important. Stand down. What is the moment in time that you decide that this incident is over? Because if not, the incident response team can go on for months. So that's an important thing. And then, of course, lessons learned. You will see some of the supporting tools and templates. Key contacts directory, something you have to keep up to date all the time, especially in a multinational where, country managers change all the time, for example. Summary of the key regulations, well, that's very important, because as a legal person, you will have to explain to your non-legal counterparts why, for example, on the HIPAA, you need to do something. And if you can just send them a document instead of starting to draft it when the data breach happens, that would be very helpful. So let me go to the next slide. So this is really the team that we're working with, what they have put in place as the most important 10 steps. So, and you were speaking about effective monitoring, that's hugely important. I won't go into that. And then the second one really has to do with 10. So nominate and train the incident response team. So the core team needs to know who does what at what time, when they need to step in. And they need to organize exercises for broader groups in the company. So both the team and the company should rehearse. And we actually do that really often. And it's very helpful, because then, you get into some kind of practice. And when then something happens, nobody is scared, you all know what to do, and you agree easily on stuff. 5 is build relationships with law enforcement. I would tend to say that is important, because some of the activities that can be criminal activities. So you also want to know who in law enforcement you should contact if something, if you need to reach out to law enforcement. The specialist resources are important. You need to know, for example, if you're working on data breaches, well, and you're in a financial environment, you may have other regulatory obligations to notify security incidents, for example, to the central banks. So you want to know, or you want to put down in your incident response plan who in the different countries that you are located are the lead regulatory lawyers, so that they can help you assess notifications outside of privacy. So these are really the main things I wanted to say practically about what you should think about.
Thank you, Helena. I think these are really great practical tips. You mentioned on your last slide, on the first slide, HIPAA, and it's true. Often a breach is global, and it might involve not just notifications under EU law, but also US law or other notifications in other jurisdictions. Barbara, Zeotap is a global company. Do you have tips on dealing with global breaches and preparing a plan that addresses global requirements?
Yes, so during this next 5 minutes, I will give you 5 tips for companies working on a global scale, so listen carefully. As a background, I will start with saying that for companies operating worldwide, such as Zeotap, it is really crucial to have good personal data breach policy. And as Helena already mentioned in more details, I would say that mainly there are 2 goals on a very high level that every good incident response plan or data breach policy should have, which is providing a framework on what a data protection breach is, and also outlining the procedure on managing, reporting, and notifying the respective authorities. And those 2 points are exactly the ones that are the most problematic for companies operating on a global scale. And to give you some examples, you mentioned in the question, Laura, a US regulation that was already discussed a bit in the previous panel. So not to repeat everything, I will just say that in the US we have a state regulation, and actually each state has regulation that obliges companies to notify affected individuals in case there's unauthorized access or acquisition of data. And on the top of that, in some of the states, less than half of the states, you would be also obliged to notify a state regulator in the event of the breach, in case there is a reasonable likelihood that results in harm to affected individuals. And then there's another caveat to that different state regulators would have different view on what is actually, what could result in harm, or what is actually the threshold that you should apply. It can get even more complicated if you deal with some special categories of data like health data or for financial data, because then in each jurisdiction you would have also separated pieces of legislation for that. Or it can be even more complicated if you are active in other countries apart from the EU or the US. To give you some examples, for example, Colombia, and then you have to look into the definition of breach of security codes, security risk, or in India, and also to address what a cybersecurity incident is, or for example, in Mexico, when you don't have to, still right now, you don't have to notify the authority, but you have to notify individuals. So those are a number of challenges that should be addressed in a good plan for good breach response plan. And coming back to the tips, so the first one is, as I already mentioned, having clear framework what data breach is in a given jurisdiction. Second is establish reporting lines to local regulators, and also you shouldn't also forget about identifying the lead supervisory authority in the EU, which may be different if you're active in different states, in different member states in the EU. Then the lead supervisory authority may be actually different than the respective one for the country where data subjects are located or where the data breach happened. But still, in the notification to your lead supervisory authority, you should remember to also include those information, right? Where data subjects are located and where the breach actually happened. The third point relates to languages. That's also something that may be problematic. Does it mean that you have to prepare templates in all the languages of all the countries that you're active in? And Working Party 29 mentions it in the guidelines and states that basically notification to data subjects should be accessible in relevant languages to ensure that this is understandable to data subjects, so that that is given in a clear and plain language. And as a rule, in general, the language used in the previous communication with the data subject could be the right one. So for example, that depends also on your business model and on the languages that your web page is available and so on and so forth. Fourth tip relates to managing your processor, because also if you work on a global level, you may have processors located in different countries, and you should also make sure that data protection, data processing agreements that you have in place with such processors reflects not only the GDPR obligations, but also potentially go into more details and include also timelines, formats, some further specifications to reflect what you have in your internal plan. And finally, education. That is also very important, not to forget taking into account extraterritorial aspects of GDPR that you should remember also about employees located in different countries, that they are also aware of the policy that you have in place and of the GDPR as well. And that's it for now.
Thanks so much, Barbara. So it's really important to think about other jurisdictions and not just about the EU, but something that we haven't mentioned yet, and Peter, I think you can talk about that, is the other legal instruments in the EU that impose breach requirements. So Peter, how do the GDPR requirements relate to the requirements under NIS directive, e-privacy directive, and even other legal instruments?
Thanks, Laura. As Helena already mentioned, there are obligations to notify data breaches beyond the GDPR. So you mentioned the financial services, but there are obligations under the e-privacy directive, there are obligations under the NIS, Network Information Infrastructure directive, and under the Electronic Communications Code. I want to focus on those. There's also the EDAS, which is on trust services. But maybe let's start with the e-privacy directive. And that is very similar to the obligations under Article 32 and 33 of the GDPR. It concerns, the obligations are on providers of electronic communication services. These are today telecom providers and internet access service providers. The obligation also refers to personal data breaches. So only breaches of personal data, not any data they carry over their networks. The structure is very similar to that of the GDPR. So there's a notification to the competent authorities, and there are obligations to notify to subscribers or individuals. And the notification has to be done without undue delay. That's a term you probably all remember from the GDPR. The terms in the e-privacy directive have been interpreted and given further guidance in a Commission implementing regulation of 2013, in which the Commission gave guidance on what is meant by without undue delay. And at the time, it was stated that it should be normally 24 hours and could be extended by 3 more working days or 3 more days. So more or less similar to the 72 hours of the GDPR. And I remember that when the GDPR proposal was drafted, this time frame was also a discussion, and some inspiration was taken from the e-privacy implementation. Net notification to the individuals is required if personal data or privacy are adversely affected, which is very similar to, again, the GDPR, which speaks about risks to the rights and freedoms of natural persons. Also, one element which is remarkable is that, and which you also find in the GDPR, is that competent authorities may request the companies or the providers of electronic communication service to notify to individuals if they don't do it in spite of their legal obligations. The content of those notifications is very similar to that of the GDPR. It's the nature, the content of the data breach, the recommendation of measures to mitigate, and some further, like the consequences and measures taken if it is to the competent authorities. So it is clear, I think, from these explanations that the links or the similarities between the GDPR and the e-privacy directive are very high. And to some extent, I think that the e-privacy directive regarding data breaches has to some extent be a kind of blueprint or at least a source of inspiration for the GDPR data breach notifications. And that fact that the GDPR has very similar data breach notification provisions in its Article 33 and 34 as the e-privacy directive leads to an overlap between the two. And that is a relatively unfortunate situation because now you have obligations under both. And the proposed e-privacy regulation wants to remove that. The regulation proposes to delete the provision on data breach notifications that will be relied on the GDPR because it's only personal data, so that is already covered by the GDPR. And the security obligations are already taken over in the Electronic Communications Code. Another legal instrument which concerns only some companies or some providers is the NIS directive of 2016. And there are obligations on data breach on security incident notifications on operators of essential services. Those are services which are really essential. It's in energy, it's the distribution and the transport network operator. In transport are airports, important air carriers, railway companies, and so on. In health and in banking. The structure is again similar. They have to be notified without undue delay. And then I think somebody mentioned at the very beginning that you don't, I think it was Dina, you don't want to get every small breach notified. And there is a kind of filter for the operators of essential services. It's the incidents having a significant impact on the continuity of the services. And that is a filter already. And then you have also obligations on so-called digital service providers, which are currently online marketplaces like Amazon, cloud computing, and online search engines. And those providers have to notify only if there's a substantial impact. I don't know, I guess the legislators had an intention to have a difference between significant and substantial. Probably substantial is a higher threshold. Let me shortly mention the Electronic Communications Code and the current framework directive of the telecoms framework. There again we have an obligation to notify security incidents if data of telecom providers is hacked or breached. And again, this is without undue delay. There's no time frame in that provision.
Thank you, Peter. Something else that we haven't talked about yet is under the GDPR, the requirement for processors to notify their controllers. And since we have Mastercard at the table, and often Mastercard acts as a processor, it would be great, Helena, if you could talk about maybe Mastercard's approach towards that obligation and maybe contractual provisions in contracts with customers.
Yeah, let me shortly try to do that. So I think you already mentioned the obligation on processors is different because they need to notify without undue delay the controller. Very often contractually that means within 24 hours. So the first thing to do, and you should point your DPO to it, and if you're yourself a DPO, you should immediately look at, in your records of processing, did you clearly set out where you are a processor and where you are a controller? Because if a data breach happens, you want to immediately take out your cupboard, your record of processing, and see what is my obligation. I think that's the first thing to be sure to do. Then practically speaking, my approach really is, as a processor, you have a responsibility towards the controller. So indeed, you have to notify all data breaches. There is no consideration of risk. And that sounds a little bit severe, I know. But what I have seen, not only in my current company, but also beforehand in other companies, is if you do that and you tell that to your customers, you actually build trust. You tell them, or the account managers tell them, guys, this has happened, this is the level of risk, this is what we're doing, you can count on us, what kind of help do you need, how can we assist you? And that actually helps in building trust, because everybody knows that data breaches happen everywhere. So putting it under the cupboard or under the, I would say don't do that, but make sure that your processes are in place. Now, one consideration for a controller-to-controller relation where there is no obligation to notify the other party, I would say in your contracts, still consider, if you put in place a controller-to-controller relationship, whether you actually need or want to know that that other controller with whom you are working has a data breach, because very often it will impact you. So you actually want to know, and the other one probably also wants to know. So it's not a legal obligation, but practically speaking, you want to keep that in mind. Contractually, well, there's, requirements around the security program, about monitoring and testing, confidentiality, etc. But for data breaches specifically, what I would suggest that you do in the contract, don't say you have to notify yourself a data breach. Tell them you need to call this number and you have to email this person at this email. Practically. Make sure that there is an obligation to take corrective action. There is the cooperation obligation. And speak about costs and expenses. Who is going to bear which costs? And then think about if there's a strong relationship between the two parties, who is going to approve the communications and the notifications? So be very clear about that.
Thank you, Helena. I think these are really good practical tips. In talking about the practical aspect of this, Barbara, when we talked about this subject earlier, you mentioned that ad tech companies often don't have direct identifiers. Same goes for Zeotap. So what is then the approach to notifying individuals?
So even for ad tech companies that would work usually with online indirect identifiers and pseudonymized data, such companies still should develop a strategy for notifying data subjects. And we already discussed a bit the definition of personal data breach, and where basically the notification to data subject exists when when there is this higher, when it is likely that there is a higher risk to the rights and freedoms of natural persons. So there are two elements. One is likelihood and one is severity. Of course, there are more factors to be considered, but in case of not direct identifiers or pseudonymized data or pseudonymization technique, that is something that reduces this risk, this high risk aspect. Does it mean that controllers may use it to avoid notifying data subjects? Well, I would say that that question can be answered with a favorite lawyer's answer, which is it depends, obviously. Because really in this case it depends. It always turns on the individual facts of the incident. And that is something that also should be addressed in the strategy or in the policy that you have in place. So basically that there are various ways of risk assessment. For example, European Union Agency for Network and Information Security, they provide a model calculation whether that is a high or not high risk. So that is one tip for this part. Have a framework to assess whether the risk is high or not, and do not assess that the risk is not high. The second tip relates to the obligation itself. So you may rely on exemptions. For example, if the data held by a company does not allow to determine the identity of the individuals, you may rely on this exemption. I mean, GDPR refers to implementing appropriate technical and organizational measures that actually render the personal data uneligible to any person. So that's one exception that could be relevant in this case. The second exception that could be relevant is the case in which the company, if the data held by the company does not allow the company to contact the individuals affected by the breach. So there's in this part, GDPR refers to disproportionate efforts. So that could be also an exemption applicable in a given case. So the second tip is, I won't tell you whether to rely on those exemptions or not, but to have in mind the accountability principle. So whatever you do, you should be able to demonstrate to the supervisory authority that you meet one or more of those conditions. And talking about the supervisory authorities, that's my third tip. Cooperate. Because if there is a high risk, there is a risk, so you notified already the supervisory authority. And GDPR mentions in the recitals that communication, that notification to data subjects should be made in close cooperation with the supervisory authority and respecting the guidance. So that's something you should also have in mind. And there's a last tip that was already mentioned by Helena as well, that you should monitor your contractual obligations as well, because for ad tech companies, that often be the case that they work with processor controller, and there may be some additional obligation to notify a breach to your commercial partners. So that's it. Yeah.
Thank you, Barbara. I think, Stewart, we've received a lot of great tips from our panelists.
We have.
Maybe it's time to open up the floor so that the audience can ask questions and maybe get some more tips out of us. There's a microphone over there.
Thank you very much. I'm Eduardo Bertoni. I'm the director of the Access to Public Information Agency in Argentina, which is the Data Protection Authority in Argentina. I have a quick question and asking for a concrete tip as well. Argentinian current law does not have the obligation to report a data breach. However, the wording of the article referring to security and databases allowed us, the Data Protection Authority, to issue a resolution requesting or ordering the obligation to report a data breach to the Data Protection Authority in a period of time, 72 hours. We were also working on a draft to modernize our legislation, the current data protection law in Argentina, and we also included a specific article saying that there is an obligation to report data breaches not only to the Data Protection Authority but also to the data subject. And we included a specific deadline there. Here's my question and asking for the tip. When we were drafting the law, we opened, for consultation the first draft, and we received some comments coming from the companies saying that it is not good to put a specific period of time because when a data breach took place or takes place, the company is a little bit crazy trying to solve it, trying to figure out what happened, and to put another obligation, which is the notification, could not help to solve the problem or could not be very useful at that time. So the tip or your comments on that. Is it okay to say, okay, there is an obligation? I know what the GDPR says. I mean, I'm not talking about, I'm talking more conceptually. It is okay from the perspective of people working on security to have this kind of obligation, or it creates a lot, some sort of disruption in a moment where the company could be in crazy time, or if I may say. Thank you.
So it's true some have criticized that 72-hour time frame in the GDPR. I know if one of the panelists wants to take that question.
Yeah, thank you very much for your question. The thing is that the important thing here is when you need to notify within 72 hours is that the DPA, the supervisory authority, knows that something happened, and the important aspect is to protect the rights of the individual. So for a big data breach, it's good that the DPA is aware and knows what is going on. On the aspect you said about the security team who is very occupied with resolving the incident, of course it's a burden to do all these notifications, but the law allows you to do the notification in phases. So you can do a slight, provide the minimum information that something is going on, and when after you resolve everything, you can follow up with more information. So at this aspect, I don't think it's a big burden for the incident response team or for the DPO to do the notification, and it can be easily complied with the law. So it's
if I may add to the contrary, actually, because I think that really depends on the severity of the breach, because in case there is, for example, breach related to the credit card details, that's obviously something that should be notified sooner than even 72 hours. But if there is, for example, someone put a mailing group in BC instead of CC, that's also something that may need notification. But then, well, that actually could be also done after 72 hours or at 72 hours. So I would say that, well, would maybe better actually not to have the so specified timeline.
Controversially, from experience of being in the room responding to incidents, I actually like the deadline. It focuses the minds of the people in working out what the actual impact is on the data subject in question. It's really important for people to know that an interim notification can be made and that it doesn't have to be detailed, but it's just a line in the sand. Also, it helps people prepare for that. So in order to be able to make that notification, you need to know that a breach has happened in the first place. And it forces, or encourages, I should say, an organization to put in the instrumentation and the monitoring to be able to detect that these issues happen and have that feedback from employees, technical people, security staff, and so on, to be able to manage these kinds of incidents. So controversial, I think it's a positive thing from my perspective.
Yeah, and if there's no discipline, no timetable, then the company will always say, well, we'll do it next week, next month. It's never the right time. So by notifying in phases, that has to be the best thing, because it's a discipline, and then they can follow up later with more details when they're ready. But the first threshold, I think, is important.
Shall we take another question?
Yeah, I'm Oliver Federmann from FITS Karlsruhe, and I have a more practical question and with a focus on prevention. So do you see chances to use algorithms or other kinds of automation regarding the prevention of personal data breaches? For example, a combination of intrusion detection systems, or like a German research project is inventing, a sort of an alerting protocol on the side of the data controller based on a software framework. Thanks.
I guess that falls to me. I don't think you'll ever automate everything. So it's old advice, but it continues to be a really sound approach. Defense in depth, it's a number of layers of instrumentation, really, and educating people that results in good levels of protection. So have you got good technical hygiene? Is everything patched in place, and is the noise removed from the environment? Have you got monitoring that detects sort of common cases where unusual things can be detected? Like somebody uploading lots of data to the internet suddenly, for example, basic example. Have you got good awareness in your in the people in front of the computers at the desks that, you know, if an email comes in, they need to question it before entering their username password in response to that phishing email. So it's lots of different controls that can help, but the automation is certainly helpful in detecting abnormal behavior. So where you can have a rolling statistical window that compares a version of normal against the current behavior. But the downside of, or the weakness of that approach is that an attack can happen very, very slowly. So even an attack itself can become normal from the perspective of the automation. So the answer is it depends.
Barbara Egli, DPO ECB. You touched upon the question of subcontractors, and that is really, to my mind, one of the spots, or I don't want to say the weak spots, because many contractors are very conscientious. But I would like to have a practical tips from you, from your experience. How far down the chain do you go? You have a contract with your subcontractor, but they have subcontractors who potentially also have subcontractors, etc., etc. How much due diligence do you actually do to know exactly what's happening down the line? Thank you.
I think that's maybe a question for Helena or Barbara.
Yeah, I'll try. It's an excellent question. It's also a difficult one. So I think contractually speaking, you do want to make sure that all the contractual obligations flow down. So that's from a liability perspective. Then also you want to make sure that you approve your processors, sub-processors. And then it's very difficult to go down another layer. So what you can do is put in place some kind of restrictions. These are the kinds of sub-processors that we never want to see in the going down line. So that is something that you could consider doing. Or certain countries.
And I think that may be also problematic in case of controller-to-controller relationship, whether you want to go down further to processor of the controller or to sub-processors. So, I mean, there's not ideal answer on the other side, because also then the controller may also request you to do the same thing, to mirror those obligations. So, yeah.
Perhaps one additional point is, I think audit is extremely important. So, you know, the processes that get information that is more than name, email, and something, you want to go down there. And you want to see, you need to establish actually these kinds of processes. I want to go every year. Those I want to go every 2 years. Those I can go every 5 years. You want to see them.
Another question?
Yes, hi. First of all, thank you, Laura. Thank you, Stewart, and all of the panelists. I think this was very interesting. Some very good practical tips, and you've covered a lot of ground. My name is Thibaut Dulst. I'm a lawyer here in Brussels, and I wanted to pick up on something I heard from, I think Dina mentioned it, and Peter as well, that they don't want to see some of the notifications of, for example, an email that was sent to a wrong person. And I think that's interesting. From the guidance that's available, it seems that the threshold is quite low to what has to be notified. Incidentally, this morning I read in a newspaper the president of the Belgian Data Protection Authority, who is talking about breach notifications, and gave the example of an email sent to a wrong person. Maybe it doesn't have to be notified. Somebody forwarded that to me, whom I had advised something different from an email that was sent to wrong recipients, which contained an annex with some personal data in it. So I had to explain again, I think this was a breach. So maybe there, if you wanna, from the regulator perspective, can explain a little bit more on what you're looking for in a notification and what you would want to avoid, because I understand you don't want to go through thousands of notifications and maybe not have the time that you want to spend on the important ones, and maybe also from people who deal with a lot of data breaches, where you draw the line and how you record your reasoning, I would say, in the register, perhaps.
Okay, thank you for the question. The assessment of the risk, I think, is the most important and difficult issue for all organizations and controllers. What we have received so far from the notification we got, it was also an example, like you mentioned, of sending information, personal information, to a wrong recipient. And in that case, the recipient have deleted that email, have never opened the information, and that was verified also from the technical log. So there was evidence that the data breach never took place. However, we were notified on this incident, and normally reading the Article 33, we shouldn't have been notified because there was no risk, so no access to the information, and it was verified by technical means. We had several notifications on that topic as well from other controllers, where they said that we asked them to delete the email, for example, and they verified they did. But in those cases, we didn't have the evidence that this indeed took place. So there we are not sure whether there was a breach or not. We need the evidence. So this is one aspect. On the other side, we are trying to provide examples where the notification needs to take place towards the supervisory authority or the data subject. We have included in our guidelines, but these examples are not many, and we will, at least as EDPS, intends to work more on providing more concrete examples to help the controllers comply with this assessment difficulty.
Yes, and I think a good example is given by the United Kingdom ICO, Information Commissioner's Office, where they have a telephone helpline where they encourage people who think they might have a data breach to call up without commitment, without legal damage, liability, to discuss the issue. We did this and this happened and that happened, and do you think it's a problem or not? And then usually they reach an agreement on whether it is a problem or not, and then they can either notify because yes it is, or they just don't bother, or they don't need to notify because it's not serious. And I think that's a good thing for the authority, because they gave loads of practical examples where they can then issue guidance based on actual examples that have happened, and then I think it satisfies all parties. There's something, maybe an incident, but it's not actually a data breach. So that's the example I like to give, and I think other DPAs could follow that example.
Maybe just to add on this question, I think it depends, of course, on the legal wording of the applicable provisions. And in the privacy directive, any data breach or personal data breach has to be notified to the competent authorities. It's different for the individuals, but for the authority, every breach has to be notified. And you have these different thresholds in the NIS, in the Electronic Communications Code. And just because we're talking about emails, just to remind that in case the e-privacy regulation has not yet entered in force in December 2020, then all emails, webmail, and all messenger services will be covered by the e-privacy directive, not by the GDPR, but by the e-privacy directive.
Okay. Hello, good afternoon. Roger Salonge, PhD student at University of Turin. I got two quick questions. The first concerns liabilities in case of data breaches. I was wondering, because Article 42 of the GDPR provides for certification and encourages companies to get certification stamps to prove compliance to the regulation. Yet Article 46, paragraph 4, the same article says it doesn't exonerate you from responsibility in case of breach of the regulation, which means a company may be certified as secure, yet when there's a breach, it doesn't exonerate me in any way, doesn't mitigate my responsibility. So do companies still have to invest in getting certificate? Because I'm sure it's not free. So should I advise a company to invest in certifications even if I know it wouldn't exonerate them? And secondly, finally, Helena mentioned something about notifying law enforcement too. So I was wondering, under criminal law, maybe I know criminal law is limited to a state. It's not like it's not regional yet. But could there be some conflict between the GDPR and or NIS directive or e-privacy directive with criminal law in terms of notification? If the breach is maybe is criminal inclined, or I mean, I'm just wondering. I'm not an expert in criminal law, but could there be some conflict between GDPR and criminal law in terms of reporting data breaches to law enforcement?
So I think we're going to leave it at that. Stewart, I know you want to give a summary of the panel at the end, so we need to allocate a bit of time for that, and we only have 4 minutes left. So I'm thinking maybe, Helena, do you want to talk about just maybe whether there's still an interest in getting a certification for companies in general, and the question about law enforcement, maybe you can touch upon that as well.
I think the cause for certification truly exists, because we have seen with our BCR certification that is so helpful, and it's not even a true certification. I think that really helps in your contracting phase, in any audits, in your discussions with your individuals. So certification is really something I think the entire privacy world should push in their companies and get to something serious. Now, on criminal law and the interface, it's important to know, and I had it when I was at the Dutch Data Protection Authority, some infractions or violations of the GDPR will in itself be criminal violations. Okay? And so the DPA may actually decide themselves to involve law enforcement in the event they find something. First thing. Second thing is I haven't seen any conflicts, unless, of course, law enforcement asks you to share your entire database with them, etc. So, of course, you can't do, because that's not proportionate, and is contrary with your obligations to keep the data secure and to only use it for certain purposes and not transfer it to third parties. So I don't see the conflict. I rather see that you may need law enforcement in some point in time if there's an important hack or an employee that has gone rogue. You really need them.
Thank you, Helena. So, Stewart, would you like to give us a little summary of this panel?
Oh, yes. I would love to. Yeah, 1 hour and 10 minutes in 1 minute. Okay. So we covered the following points. Motivation for data breaches when somebody's hacking in. It could be money. It could be someone with a social engagement, activism it's called, or someone have a campaign that want to achieve some social good, what they think is social good. They could be a government hacker, but also companies, you should be aware of social engineering. That is people trying to pretend to be a finance director or something like that. Always a good advice is to have technical hygiene, things like good password discipline. We talked about the subject of what is the threshold for harm. This is very important to always bear in mind. What is the harm to individuals and the impact on the rights and freedoms of individuals? When looking at reporting to a national data protection authority, who is the lead authority, which is the lead authority in the European Union, and not necessarily the place where the incident took place. Bear in mind to, when contacting individuals who have suffered from the data breach, you have to think of languages. You need to prepare documents to communicate with them in the language they will understand. In terms of timing, you have to notify without undue delay. And then we had that discussion just before about, is it best to inform first or later? And I think I would suggest that it's best to inform first in the first 72 hours and then go to more detail later. Other points were have good training, rehearsals in your organization, have specific people who are responsible for different things, the technical analysis, the legal person who decides whether it's a legal actual data breach or not, and someone who will approve communications. Get them ready in advance, and then you will have a template that you could then adapt when it comes to it, rather than starting from nothing. Well, that's probably enough in the time, yes? Does that cover most points? Anyone feel their most important points have not been covered? No?
All good.
It's all good, all right, thank you.
Thank you, Stewart. you.